Hi, my name's Joe Monahan. I'm from the Monahan Law Group in Chicago. We're a 9-lawyer firm who represents individuals with disabilities and the professionals who serve them. So today, I want to talk about some practical things that you can do in order to obtain confidential mental health and other records. So the first thing that's important to think about when thinking about confidential mental health records is the basis of all the therapeutic relationships that therapists have with their patients is confidentiality. People tell social workers and psychologists and psychiatrists their most personal thoughts, their dreams, their fantasies, and they have an expectation that those records and communications that they share with a therapist are confidential, are personal, and will not be shared with anyone without their permission. There are many laws that impact how confidential information is stored. The primary law that we'll talk about today is the Illinois Mental Health and Developmental Disabilities Confidentiality Act. We also will explore briefly the notion of confidentiality under HIPAA, the Illinois Domestic Violence Act, the federal alcohol and drug regulations. There's also information that is protected under the AIDS Confidentiality Act, the Juvenile Court Act, and other acts. But today's topic will cover mostly what the rules and regulations are concerning the confidentiality of mental health records. We start with the notion that all records and communications are confidential. And so the first question that we have to ask is, what are records and communications that are protected? The idea is all of the records and communications are confidential, even the fact that a person is a recipient of services. And what kind of services are protected? Well, under our Confidentiality Act, that will include all sorts of different things, including the examination, the prescription of pharmaceuticals, the notes that are kept by the therapist. All of those things should be kept in a record and are confidential. Interesting, the question of who is a therapist. And our law in Illinois provides that psychiatrists, psychologists, medical doctors, social workers, licensed marriage family therapists, all of those people are considered therapists under the Confidentiality Act. In fact, a person who is a recipient of services who believes that a person is a therapist also can have a confidential communication. Another unique thing about the Illinois law is the fact that a person who's in the presence of a therapist also has an expectation of privacy. So for example, if I go to see a therapist and I bring my partner or my wife or one of my children into the session, they too have an expectation of privacy, which is protected by our Illinois law. Let's talk for a moment about what is a mental health record. Again, the law protects all records and communications that are shared with a recipient of services and the therapist. But I find an area where there's lots of confusion is in the notion of what is a personal note. A personal note is a legal defined category of notes that are kept by the therapist. They include 3 content criteria which are very important to understand. In order for a note to be considered a personal note, it has to fit in one of the 3 content criteria that's provided in the law. The first content criteria is information that's disclosed by a third person to the therapist on the condition that it will never be shared by the recipient of services. For example, if I am in therapy and my wife calls the therapist to provide some information about me, that information could meet the first content criteria in a personal note. The second content criteria in order to meet the legal definition of a personal note is the notion that I tell something to the therapist would be injurious to my relationship to others. An example of that would be, let's suppose I tell my therapist that I'm going to get divorced. That would be very injurious to my relationship with my wife. The third content criterion, in order to meet the definition of a personal note, is the notion of the therapeutic stuff that therapists do. Their hunches, their reminders, their notes to themselves. If a note meets one of those three content criteria and is kept separate from the regular record, it can be considered a personal note. The import of personal notes for lawyers is that they are not discoverable. So if a therapist keeps notes properly and considers them personal notes, they will not be discoverable. How does one determine whether the note meets the criteria, the definition of a personal note? It has to be subject to an in-camera review by a judge, who will then have to decide whether the note meets the legal definition to be considered a personal note and therefore not be discoverable. It's a very important tool that therapists have in order to keep confidential information away from the legal process. If done properly, this can be a very, very effective tool. Lawyers need to know about personal notes and the content criteria in order to determine whether they will have access to these notes when they subpoena them. One of the things that I tell therapists is whenever anyone is asking them for information about one of their clients, the first thing that I tell them to do is just say no. The second thing I do to tell them is to say, who's asking? So first they say no, second they say, who's asking, in order to determine whether there's a legal route for them to share this very private information. One of the most common ways that information is shared is through a written authorization of information. Many lawyers use copies of authorizations that they've obtained over the years. The Illinois Confidentiality Act lists specific requirements that need to be provided. In fact, these requirements are more specific than HIPAA. One of the areas that we see most common that mistakes are made is the failure to get a witness on the authorization. HIPAA does not require it. Illinois law does require it. So be ever attentive to the need when you use a written authorization form that you use a form that includes a witness's signature. A very easy way to make certain that you have the most up-to-date authorization form is to go to the Illinois Department of Human Services Library of Forms and obtain their authorizations. They do an excellent job of providing up-to-date forms that are legally appropriate, and they also include what is needed in the law. So I highly recommend that if you're going to use an authorization, that you use the resources that the State Department of Human Services has provided. Another common mistake that we see on the form is the failure to put a timeline on how long the authorization is good for. If the authorization has no timeline included in it, the authorization is only good for the date that it is received by the person whose records they are seeking. So for example, if you as a lawyer are attempting to get records from a psychiatrist and your client signs an authorization for the psychiatrist to release that information, but does not include the date for which the authorization expires, it's only good on the date that the psychiatrist actually receives the authorization. So another good idea when you're preparing authorizations for your clients to permit you to access confidential information is make certain that you have a timeline which will permit you to get updates when they're needed so that you don't have to continue to get additional authorizations for the release of information. Just in closing and thinking about the whole issues of confidentiality, a couple of things that I would think about. First, all records and communications concerning mental health are confidential, kind of. Second, in order to obtain confidential information, one has to secure from the recipient of services an authorization to release that information, or alternatively, they have to obtain a court order to obtain access to that record. Mental health and behavioral health professionals zealously guard their clients' confidentiality, and so we as lawyers have to become very adept at how to get access to this confidential information in whatever reason, for whatever reason that we will need it. In our next talk, we'll talk specifically about practical ways to obtain court orders to obtain confidential information. In the meantime, the Illinois State Bar Association Mental Health Law Committee has a wonderful resource through its newsletter. I highly recommend that you go to that. And I also recommend that you go to the Illinois Department of Human Services website to get access to the confidential authorizations for release of information. Thank you.